And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual.
Okay, right away, this is a huge detail. The prosecution could have pushed for habitual offender status, which in Texas can absolutely explode a sentence, but instead they capped it at 20 years. Translation? The defendant already got a major break walking into this courtroom. The real question now is, did he do anything to convince the judge he deserves mercy on top of that?
Habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health, as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
And this is one of the hardest parts of sentencing hearings to watch, because family support matters emotionally, but judges are looking for something else too: accountability. You can almost feel the defense trying to humanize him here with the mental health issues, the medical problems, the family presence. But is that enough when the criminal history is this long? Let me know in the comments. Should family support reduce someone's sentence?
What is the status of parole?
No, we're waiting on the way.
We're on this.
Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for a TDC sentence in the high range on this.
That line landed hard. Prosecutors love building a pattern argument, and that's exactly what's happening here. He's basically telling the judge, the only time society is safe is when this man is locked up. That is devastating in a sentencing hearing. At this point, you can already feel probation disappearing off the table.
So, Mr. Torin, in 2019, you received a 15-year sentence. So you were only not, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously.
I got out August 23.
So you got out in 2023, and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you, as a grown man, have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison and you've chosen not to do that, it's
11th and 12th felony offenses. Think about that for a second. By the time numbers get this high, judges often stop viewing cases as isolated mistakes and start viewing them as a public safety issue. And notice the judge's tone changing here. This is no longer just about punishment. This is becoming a courtroom lecture about choices, addiction, and repeated opportunities being wasted.
I mean, your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's such a. I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history. And the fact that you're on parole and you commit 2 more offenses and you're still using drugs and you haven't made, it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794.
This is the moment that sealed it. Not the theft case, the chase. Judges take vehicle evading cases incredibly seriously because innocent people can die in seconds. And when the judge starts listing intersections, near collisions, crashing through fences, that means those facts hit her personally. You can hear the frustration building with every sentence. At this point, a maxed out sentence was basically inevitable.
Sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. In cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Now here's an important legal detail a lot of people miss. He got 2 20-year sentences, but they run concurrently, meaning at the same time, not back to back. So it's effectively 20 years total instead of 40. Considering the judge clearly viewed him as a danger to the community, that concurrent ruling may actually be the last bit of leniency he received in this courtroom. Do you think the sentence was fair, or should it have been even harsher?